Hello. Have you purchased a fitted kitchen that is faulty, not as described, or not as seen? Then you are entitled to a refund, repair, or replacement. When you buy a fitted kitchen, the Consumer Rights Act 2015 states, it must be fit for purpose, as described, and of satisfactory quality. If your kitchen develops a fault, perhaps the doors are badly fitted, or the drawers wonky, you only need to give a retailer one opportunity to remedy the same fault. Firstly, ask your supplier if they have a complaints process. Large firms do, small traders may not. You need to give your supplier every opportunity to settle it before you take legal action. Supposing the fitted kitchen does not look like the one that you saw. According to Section 13 of the Consumer Rights Act 2015, it says goods to match a sample. Under this section, if a consumer enters into a contract for goods based on a sample, the final goods delivered must match that sample. The exception is any differences brought to your attention before the purchase was made. In this instance, the supplier must put it right. Whether it is a kitchen retailer, DIY store, or handyman. Call the supplier and explain, calmly and politely, what it is wrong. Fingers crossed they will fix it. But, even though they were nice, and promised you fast action, nothing happened. After some wasted time, you still have the wrong or faulty kitchen. Time is ebbing away. You have a short-term right to reject faulty goods, within 30 days under Section 22. Part 3 of the Consumer Rights Act 2015 and get a full refund. No questions asked. No retailer will ever tell you that. You simply have to prove that the goods are faulty. Not all suppliers are bad, but not all suppliers are good either. They can all be very nice and say all the things that they think you want to hear. But they may do nothing to fix the problem. Time is against you. After 30 days have passed, and up to 6 months from the date of fitting, the onus is on the supplier to prove that the kitchen was fault-free when it was fitted. That is difficult with the wrong kitchen, but easier with a wonky drawer or door. You are entitled to one repair free of charge, or a refund, or a replacement. But you have no options. You lost that in the first 30 days if nothing was done. That was when you should have called Impel Legal to act on your behalf. Now, the onus is on you to prove that the kitchen was faulty or wrong when sold. You may need to get an independent survey from a qualified technician. You could research the brand for common faults. It could prove a historic issue, overriding the need for a survey report. If this sounds overwhelming, we could undertake the research as part of your claim. The Consumer Rights Act 2015 gives you an implied statutory warranty in law. Up to 6 years in England and Wales and 5 years in Scotland. You can ask Impel Legal to act on your behalf. Email us at mail@ukhq.com and provide a brief outline. We will submit a proposal for you to consider. Whether you choose our paralegal or go it alone, you need to gather evidence. Take photos of everything that you are unhappy about. All complaints should be in writing. Emails are a great chain of communication. Put a deadline on everything. This is especially important within the first 30 days. Suppliers might drag the case out until you have gone past the short-term right to reject goods under the Consumer Rights Act 2015. Check out our website www.impellegal.co.uk.